This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
I was given a presentation 2 years ago with a judge in California who does family court, and it was a presentation on phones and digital forensics. And he was saying how often that happens in family court. It's usually disputes over people who are trying to get divorced or fighting over kids or trying to get restraining orders, and they do not have attorneys. They're appearing pro se. And it is, he said, quite the experience, because he said every single case, someone tries to hand him a phone and say, look at this text string. It proves I'm telling the truth. And he said, judges really struggle with this. Should we accept it? And I was like, absolutely not. And he was like, why? And I grabbed my phone, and in about 10 minutes, I set up what looked like a text string where he was threatening my life. And it was me just sending messages to myself, changed the name of who sent it, and then manipulated the screen. And I was able to do that in minutes. And so that is one of those types of situations where you would need something else besides the phone to prove that didn't happen. I don't know about every case, because sometimes that's not the dispute. Sometimes the dispute isn't, I didn't send the message. Sometimes the dispute is, that's not what I meant. And if the dispute is, that's not what I meant, you don't need an expert. But if the dispute is, that's not, I didn't say that, then I think, yes, I think having the phone is not sufficient.
Trying to explain the American trial system to people who are not familiar with it, it helps to remember we have an adversarial system. Mm-hmm. And you notice even in the rules that John and Andrea talked about, there's a notice requirement, so that before the trial, each side is supposed to tell the other side what they plan to do. And the idea is to encourage the two sides to work out what they agree upon and what they dispute. So when you have a true dispute over the authenticity of something, well, then you may have to go into the more technical aspects of the rule. But if both sides agree, and as John said, they're not really fighting about what the documents say or what the emails say or the text messages say. They're fighting more about what they mean, or maybe the issue is something else. The parties can agree that these are authentic and that they're relevant and that they're admissible. So the system kind of relies on both parties who are adversaries to raise objections or to reach agreement if they can.
The cool thing is that anybody can do the hash analysis. Most of the hashing tools are free. So a lot of them you can just download and do a hash yourself. There are some that are pretty expensive that do a little bit more. But if you want to just know at a file level, the programs are free to generate the hash value. So I suggest playing with that and downloading one just so you can see what that's like.
Second question on whether there are limitations in terms of seriousness of case and the like with respect to a party's ability, the government's ability to seek a warrant, or a party's ability to seek information from a third party through a subpoena. Generally, no. There are a number of exceptions to the warrant requirements. The Fourth Amendment to the United States Constitution, which prohibits unreasonable searches and seizures, and requires probable cause for a warrant, has generally been interpreted to require a warrant, there's a presumptive requirement of getting a warrant if you're going to go searching data that's in the possession of a private citizen without their consent. And of course, there are a million exceptions to the warrant requirement, but generally they have to do with, consent or searching incident to arrest or exigent circumstances, emergencies and such. There's no murder exception to the warrant requirement, especially with respect to digital evidence. Our Supreme Court has actually been, I would say, unusually willing to require to enforce a robust warrant requirement when it comes to digital evidence like cell phones and cell site location information and GPS data, more so than other types of evidence. With respect to subpoenas, I think it's worth noting that generally you don't even have to go in front of a judge to begin with to get a subpoena, whether it's a misdemeanor, like a very minor crime or murder. You really just need yourself to know that it's material to the case. It's relevant to the case. You need the information. And then it's up to the third party. If they think that you're asking for something that's not material, it's up to the third party to say, no, I'm not going to comply with the subpoena, and try to get the court to agree with them and agree not to enforce the subpoena. There are also some records, like an alleged victim's medical records, that are so sensitive that you do actually need to go and have a hearing in front of a judge to be able to get that information and make a much more serious showing. But otherwise, it's if you're the government, at least, it's pretty easy to subpoena information, and you don't need probable cause to do so.
If you're using the wiretap statute,
yes,
which means a real-time interception of a communication, that's limited to very serious crimes, because that's such an invasion of privacy to intercept somebody's real-time communications. But the warrant requirement, as Andrea said, and subpoenas are not limited by the crime you're investigating.
Absolutely.
Although the list for wiretapping crimes is pretty long.
Where we've seen this come up first is with social media. So one of the things for authentication says it has to be a business record. So it's a complicated system of rules and laws. But when we get to authentication, one part says it has to be a business record. And what is a business record? I own a business. The traditional one is if I wrote on my letterhead a note to my secretary that said, go take $500 out of my trust account and give it to Andrea. That is a business record. It's a record that I generated for my business. And for some reason, people thought that was not hearsay, meaning it was not an out-of-court statement. And so how that would work in practice is my secretary could come to court and she would say, yeah, that's John's handwriting. Yeah, he wrote that note to me. And yeah, that was in the normal course of business. And if that happened, the document comes in. So that is a standard way when we think about the business record. So if I go to Facebook and I post on Facebook that Andrea Roth is a mean, terrible human being, would Facebook be able to certify that that record is authentic? And there's actually, it's more complicated than you would think. I think the answer is clear. I think the answer is absolutely not. That is not, that is not a business record from Facebook. No one from Facebook created it. It was put on their platform. But there are two courts from the same circuit within the United States who have both looked at this question and reached different conclusions. So I think 902.13, when we get there, also has a cross-reference to Federal Rule of Evidence 8036, which is the business record exception. And the question is going to be is this truly your business? Where I think that this really is going to come in is that someone is going to work at a big university or big company, and they're going to say, I'm the IP specialist for this company. I certify that I took data from our servers and I copied it and I provided it to Andrea. I think that's how we're going to see it play out in practice, but we still are sort of kind of figuring out where that's going. They really were, and that's a situation where I think the federal, that committee who wrote that rule, I think they were really trying to be forward looking and thinking about how to address technological issues that they were failing on. I think they just could have done a better job.
So the example you gave, if the question is this an authentic post on Facebook that John posted to his account? Then it would seem the business records exception, which we still call it business records, but it's a record of regularly conducted activity. But the content, what you said about Andrea is still hearsay. And so unless some other exception applies, that would not come in. But, Facebook is essentially the custodian of records, as if Facebook was Bank of America. Bank of America doesn't really care, why you wrote on your check or your deposit slip, but they can say this, we found this in our records, and this is an authentic copy of our records. Is digital different in that way? Is there something?
I think so, because first I want to answer the hearsay issue, and the example I was given, it should be more clear. It was a criminal defendant, so it was really, was it hearsay or not hearsay? And if the defendant wrote it, it was not hearsay. So that's okay. But as far as the business record, what is Facebook's business? And I mean that seriously. With the bank, I think you could say, yeah, if you have a bank, then you're banking. And so I think that makes the business record exception a little bit easier. But if you look at what is the true business of Facebook, is it selling advertisement? Is it bringing people together in a social community? What is it? And I think that's why we have courts, even in the same circuit, that come out differently, because there's a dispute about what Facebook is. So I don't think it's digital as much as it's growing technology like social media, and what do we do with that type of technology that's making a lot of people think differently about it.
In one of those cases, the court did not accept the evidence from Facebook. They said it didn't qualify as a business record and wasn't properly authenticated. So I guess there are examples where courts have not accepted the authentication. But as you can see, every one of these questions leads to 3 or 4 more questions. It's a complicated area, and a lot of this is still quite new.
The other thing is we're talking about ways to save time and money to get the post in without having someone to come testify. There are other ways that information could come into trial. Someone could testify that that was my account. Someone else could testify that they were chatting with me. Someone could testify that's consistent with the way I normally type messages. And so there are other ways. From an appellate standpoint, courts sort of decide, well, it got in or it didn't get in some other ways. They sometimes don't care as much, but you don't lose just because you don't win on the 902 issue.
And there are cases going both ways on emails too. And they've got this long list of, types of circumstantial evidence, and it either makes the cut or it doesn't. I don't know if there's a post 2017 email case, but there's definitely a bunch going both ways pre 2017.
There's 2 companies competing companies that often have the ability to get into locked iPhones. One of them is a company called Gray Shift that has a device called Gray Key, and the other company is called Celebrite, and they have something called Celebrite Advanced Services. It really is a cat and mouse game. From week to week, Apple is changing its security settings, and every time it does that, it changes the ability to get into the phones. And this type of forensics, they call it exploits, like you're trying to exploit a weakness. It changes so rapidly. I couldn't tell you the answer on any day-to-day basis. The other concern we had talking about validation is Gray Key, for instance, has a very strict rule that if they sell you one of your devices, you're not allowed to tell anybody about it, and you can't let anybody look at it. It's a very, very strict contract, and it's only available to law enforcement, which means we have an idea as a community in the defense of how it gets into the devices, but we don't know for sure. And the concern we have is we don't know if they are hurting any of the data on the phone when they're trying to get into it. So that's one problem. The second thing about it is that once when they use them from sort of like a practical standpoint, I've been told that sometimes it takes weeks or months for them to get into the device. So it's not always instantaneous. So even when they can get in there, it often takes a long time. So, but yes, we can often get into them, and it is a cat and mouse game.